Hey YouTube, how you doing? This is Adam D'Angeli, professional political hack, and today I'm going to be doing something a little bit different. This is only my, I think, fifth or sixth video on this channel, and for the most part, what I really want to be talking about is what's going on nationally in the news, in the fake news, covering how the media misleads people. But today I'm talking about something completely different. Now, I work in the Michigan legislature, and I really don't want to talk about those kind of politics very much here because as an employee of a representative, John Riley, the fact is that even though I can say that I'm home, it's after work, my opinions are my own, anything I say could be ascribed to my boss, and that's generally not fair. So I don't want to get into state politics very often, but in this case, I thought there's an issue that has come up in the state legislature twice in 1 week, and actually has come up before in some really enormous ways. And that is when there's a policy idea for how we can protect workers by making the employment agreements that they have illegal. Now, when I say it that way, it sounds like it might be a bad thing, but if you think about like minimum wage laws, they're tremendously popular. So there's a lot of economic misunderstanding out there about that. Now, there are a lot of videos on the internet about minimum wage laws, but there is a number of bills coming out now on different different types of employee protection laws, but they all actually amount to the same thing. So let me explain all this, and I'll start from the very basics. When we're talking about an employer-employee agreement, what you're really talking about is a voluntary contract, and those are governed by the same supply and demand laws as when you're buying consumer goods. If you have, why is a pack of gum $1? And it's because of supply and demand. I'm not going to get into the very most basic aspects of that, but think about an employer-employee agreement. It works kind of the same way. If I want to pay a kid to mow my lawn for $20, and another kid comes along and says I'll do it for 15. That's an increase in supply. And then if my neighbor says, well, I'd like to pay to mow my lawn, the kid says I'm too busy. So he says, well, I'll pay you 25. That's demand. It works the same way, and that's why we have. This is basic price theory. So then the next question is, what happens if you have a minimum wage law that says that paying someone $5 an hour or $7 an hour is too little. You can't pay that someone that little. And the hope in the minimum wage law is that if you just say you can't pay someone only $5 an hour, let's pay them at least 10, for example, then they'll all make 10. And it doesn't work that way, of course, because it's go back to the pack of gum. Let's say the government comes in and says you can't buy a pack of gum for less than $10. Well, everyone would say, well, gum's not worth $10. I guess I'm not chewing gum anymore. And so, and likewise, if the government came in and said, you can't pay a fast food employee less than $100 an hour, he would say, well, gee, I can obviously see why that wouldn't work. Every business would go under. Well, now the government comes in and says, well, okay, we're not going to charge you $10 for a pack of gum. How about $2? Well, it has the same effect in just a very much more muted way. Some people will say, well, okay, I'll pay $2 for a pack of gum, fine. And a lot of other people will say, I'm not going to pay $2 for a pack of gum, And so to that extent, that many fewer people are buying gum. So if the government says, well, okay, we can clearly see why $100 an hour for a fast food employee is unreasonable. How about we say $15 an hour instead of 7.5? Well, likewise, the government will say, people will say, okay, well, that won't completely put us out of business, but it may be more economical for us to therefore have, say, a computer machine to take people's orders instead of having someone at the counter, you see. And, of course, that's what we see happening at Kroger and at McDonald's and every place else, is the government having increased the cost of labor, they're causing unemployment. Some people will make more. But if you think about it, going back to the basic of supply and demand, if the voluntary agreement between the employer and the employee is the rate that they made, And the government then says, the contract that you have is now illegal. Only one of two things is going to happen. And not every business is going to say, okay, I guess we'll just have to pay our employees more. No, some businesses can afford to pay their employees more. Some businesses will do everything they can to pay fewer employees. Some businesses can't afford to pay more employees, or the employees that they have, and can't afford to lay anybody off, so they go out of business. And that's what happens. I mean, that's the cost of, if you increase the cost of doing business, someone's going to go under. That's just the way it works. It's basic supply and demand. And the fact is, in any competitive industry, there's business on the margin. So that's minimum wage. That's fairly well understood. Now, well, I say fairly well understood, but understand, this was almost on the ballot in Michigan just a couple of years ago. Had this passed, it would have devastated the restaurant industry. And only because of an esoteric procedural maneuver was it possible for the legislature to have this not put on the ballot. That could be reversed at any time. It could happen again in a few years. It could have been a different outcome when this was taken to court. So only by happenstance, or by a number of variable factors, was it that this wasn't put on the ballot and passed by an electorate that mostly doesn't really understand how this minimum wage thing works. And at the same time, they were also trying to pass a mandatory paid leave law, which is actually even more popular than the minimum wage. So, and this, by the same maneuver, didn't actually happen. But now the question is, okay, well, what about mandatory leave? Well, it's the same kind of thing. To an employer, it's not about how much you, the employee, makes. It's how much does it cost me to hire you? So what's a benefit? Whether that's paid leave or health coverage or what have you, it's the same as a wage, basically. I mean, it's a proxy for money. Now, there are complicated reasons why, for example, because of tax benefits, that it's cheaper for an employer to give you health insurance than for them to give you money to buy your own health insurance. It shouldn't be that way. It happens that it is. But that's because of bad policy. But in essence, benefits are a proxy for money. So if the government says you must pay your annual employee, your salaried employee, for 40 hours of paid leave, that's just basically the same thing as saying you must pay your employee more. So if you have an employee who's making, say, $40,000 a year to work 52 weeks a year, and now the government says you must give them, let's say 40 hours a year. Let's say 80 hours a year. So basically 1/25 of their time is now free. What's the employer going to do? I mean, think about the supply and demand equation. They've just said that now the cost of this employee or this employee is 1/25 more, so 4% more. So what are they going to do? They'll reduce their pay by 4% to come to the same outcome. Because that's how it looks to the employer, is whether they're paying you in salary or paying you in health coverage, it's just a cost. It's just a proxy for money, right? So that's paid sick leave. So now, what about other less common employer provisions or provisions in an employer agreement? Well, let's take, for example, what came from the legislature and the Commerce Committee just this past Thursday, and that was a proposal by Representative Mari Manoogian. Let me put this on the screen here. This is House Bill 4874, and what this bill is doing is it's as you can see, it's co-sponsored by a huge number of Democrats. It might not be a complete majority of Democrats. I haven't actually counted them out, but it has the Democrat leadership on there. There's Minority Leader Greg, there's Minority Floor Leader Robbie, and it looks like 36 others. So Democrats, if they had the majority in both chambers, this is a bill that might well become law of the land. And this is a bill to amend the Michigan Antitrust Reform Act, which is an interesting place for it to be. But what it's doing is, it says, an employer shall not obtain a non-compete agreement from an employee or applicant for employment unless X, Y, and Z. And if you look in, looks like the third paragraph, an employee shall not, cannot, may not request or obtain a non-compete agreement from an employee if they're a low-wage employee defined as 15 an hour or 150% of the minimum hourly wage or X, Y, and Z. So they're saying for a low-income employee, a non-compete agreement is illegal, and for everybody else, there's also these new conditions to be imposed in a non-compete agreement. Now, let's think about this. What is a non-compete agreement for an employer? Well, basically, what non-compete agreements are about, for the most part, and we're going to look into some detail at the examples offered by the sponsor of the bill in the committee hearing last Thursday. But basically, what the non-compete agreement is about is retention and training. Let's say you're an employee, and we're not going to get to the low-skilled example yet, although we will. But let's say you go to work for a company, and it's highly specialized what you do. So there's going to be an extended period of training. The employer doesn't want you to be trained at their expense and then immediately take a job with a competitor because they don't want to train their competition at their expense. But, as an employee, they will typically train you either for free or, typically they'll pay to be trained at their own expense. So they don't want you to go out, take the benefit of their training, and then a competitor will say, well, gee, if you don't have the skills that we need, we got to pay to train you. But if we can just pay someone a little bit less from a competitor, that's great for us. And so that's where non-compete agreements came from, is the idea that there's an investment in having someone come to the company and be trained. It's a value. So if the government comes in and says, we can't allow non-compete agreements, what's that going to do to the employee? Well, if you take away the employer's ability to protect their investment, it's going to come out of the employee's salary because you've taken away something that's of value to the employer. So you as an employee are now worth less because they can't, your salary is one form of compensation. Your training is an investment. So if you take away the benefit to the employee is now worth less. Does that make sense? I hope so. So now let's think about how this applies in a low-wage environment. And the example we're going to see in a moment is Jimmy John's. Apparently, I didn't know this, but apparently what Jimmy John's does is they require their employees to sign a non-compete agreement too. Now, Jimmy John's is a job that requires zero brains. And let me be clear, I delivered pizza in college. I understand, but delivering food, and Jimmy John's especially. I've been a cook too. There is maybe a tiny bit of value in having a skilled cook who knows how to make the food at the business. And you don't want them going off and working for a competitor that you just pay to train. But it's not like working at a high-skilled job. So the theory is the only reason why Jimmy John's has these agreements is for leverage over their employees. Because if you're making sandwiches, they don't want you to go work for a competing sandwich maker. Now, there's a number of problems with this reasoning here. First of all, because as an employee, that's a minus. If you have to sign a non-compete agreement as a condition of employment, some amount of employees are going to say, I'm not going to sign that. I value my job mobility. And at Jimmy John's, now think about this. If you're qualified to work at Jimmy John's, you're qualified to work at McDonald's, you're qualified to work at Subway, et cetera, et cetera, et cetera. So if Jimmy John's will offer you a job, why wouldn't Subway? And why would you take a job at Jimmy John's if you could take a job at Subway? Well, the answer is because they'll pay you more. But if Jimmy John's doesn't pay more and requires you to sign a non-compete agreement that the other company doesn't, this gets to the basic aspect of the free market of supply of labor. If there's no specialization, then there's no incentive for the company to demand a non-compete. And likewise, think about it from the PR perspective. If Jimmy John's is abusing their workers, why wouldn't that become an issue from a PR perspective. If they're the only business in town that says we won't hire you unless you sign an agreement saying that you can't work for a competitor, then that's a disincentive for anyone to go work for them. It's a disincentive for their publicity because people don't like that. So let's look at how this played out in the hearing in the Commerce Committee last week. Let me switch my browser over here to the video and hit play.
Chairman and members of the committee for giving me the opportunity to speak today. I'm here to testify in favor of House Bill 4874, which would make common sense reforms to ensure that we, as a state, are truly a land of economic opportunity and a place where an individual actually has the freedom to work. Like many of you, I was proud that we passed bipartisan legislation for the expungement of certain criminal records, and in the previous term, folks prioritized workforce reentry and rehabilitation in our correction system. However, our state is lagging behind in several others in reforming employment agreements for folks who are either working hard or eagerly waiting, not for the interview or that suspenseful callback to hear that they've got the job, but for enough time to pass in order to even apply for a job.
Okay, hold on. Let me make a point here. Waiting for time to pass to apply for another job. Now, Jimmy John's is not the only job on the planet that requires zero brains. There are other jobs. Even if you sign a non-compete agreement with Jimmy John's, and that only precludes you from working in, and she'll say in a moment, neighboring restaurants that make sandwiches. You can still apply to flip burgers. You can still apply to be any number of other jobs that don't involve skills. So it's not that the non-compete renders you completely immobile. It just says you can't work in a competing sandwich shop. Now, again, this still seems silly that Jimmy John's would actually have this. It's stupid. They really shouldn't. There's no reason why they need to hoard over their employees. They're not that important. They really aren't. But this is hitting a fly with a hammer here. Anyway, let's continue.
Specifically, this legislation would amend Public Act 274 to better define Michigan's laws regarding non-compete agreements. Specifically, it would also limit the use of these agreements for low-wage employees and improve transparency in the use of these agreements for all workers. In October of 2014, a Jimmy John's employment agreement revealed that virtually...
By the way, let's go back for a second here. I want to look at this bill because they're talking about this. She's talking about this from the perspective of the Jimmy John's incident. But here's the problem with legislation. It doesn't always just affect the one thing that you're thinking about. So you've got these provisions in here. An employer shall not obtain a non-compete agreement from an employee or applicant for employment unless the employer has done all of the following. Provide applicants for the position with a written notice of the requirement for non-compete agreement. Disclose the terms of the non-compete agreement in writing before hiring the employee. Well, yeah, that doesn't actually do anything because when you sign your employment agreement, that happens right then and there anyway. I mean, if it said, not more than 10 days before signing an agreement, but that would cause other problems. But yeah, I mean, typically it happens upon hiring. Here's the non-compete agreement. You don't like it, don't be hired. And then there's this one. Posted this act or a summary of its requirements in a conspicuous place at the worksite where it is accessible to employees. Oh, good. So make every employer who has a non-compete for any legitimate reason prominently post, we are requiring that you all non-compete. That actually is probably, a morale killer. I mean, it sounds like to me. Maybe a small thing. Maybe. But also just one more hoop to jump through. One more hazard for a business to avoid, that's insurance costs go up for, litigation insurance and so on and so forth. And then there are, of course, the other provisions too. But let's get back to the sponsor of the bill here and what she's saying. Here we go.
Actually, all employees of the company were being made to sign agreements that barred their workers for 2 years from taking a job at another company that, quote, derives more than 10% of its revenue from selling submarine hero-type deli-style pita and or wrapped or rolled sandwiches, which is located within 3 miles of either the Jimmy John's location in question or any other such Jimmy John's sandwich shop.
10% of selling rolled sandwiches. Well, gee, so it doesn't apply to burger flippers. I mean, and here again, so Jimmy John's is non-compete. They make it sound like you're enslaving them. If they sign this, you can't get hired anywhere else. It's not quite that simple. And Jimmy John's is a fairly popular franchise, but there are other restaurants that aren't within 3 miles of a Jimmy John's. I mean, in a busy city, maybe not, but in other communities, there's probably plenty of them. And again, there are many other non-skilled jobs out there besides just sandwich maker.
Essentially, that barred employees from working in any restaurant, from a Fortune 10 company to a family-run mom-and-pop small business on Main Street that sold sandwiches within 3 miles of any Jimmy John's. Like most people,
By the way, there's another aspect of this to talk about, which is enforcement. Do you think Jimmy John's is going to actually sue any of their employees that go out and work for a competitor? What are they going to do? Tell their valuable trade secrets about how they sell cold sandwiches with mayonnaise, lettuce, and tomato and deli meats? I mean, it's not exactly a huge trade secret how Jimmy John's does business.
I was absolutely shocked to learn just how restrictive these agreements were and how broadly they were being used. One publication summed up the thoughts of most people with a headline reading, "Jimmy John's non-compete agreements are utterly psychotic." Subsequent news reporting revealed that it's not just Jimmy John's that was abusing these restrictive employment agreements. Many other fast food restaurants were using similar agreements for the sole purpose of limiting the ability of their workers to leave for other opportunities.
How does she know that was their sole purpose? That's not citation needed. Prove it. You can't just say for the only reason of capturing their employees.
Studies show that 1 in 5 American workers is subject to a non-compete agreement. And while I understand that there are some instances that require those non-compete agreements, these low-wage workers, we're talking about 14% of folks who do not have college degrees are subjected to these non-compete agreements. These agreements were originally designed for mid to high entry employees, and they've been abused far beyond their purposes. There is subsequent action taken at multiple levels of government in response to these reports. A number of state attorneys general filed lawsuits against fast food companies to stop the use of these agreements, and in response, many fast food companies have voluntarily stopped using them.
Okay, a couple points here. First of all, it's elitist to say that, only because these poor low-income workers don't know what's best for themselves. Spoken from someone that's attended college. No, not everyone that it works in a low-income job is a complete dummy, and doesn't understand that when an employer says you must sign your rights away, that there's a price in that, there's a value in that. But secondly, good job saying attorneys general, not attorney generals, it's attorneys general. Okay, third thing, the employers didn't change their policies just because they were sued, just because they assumed they were going to lose in court. They changed their policies as a PR matter. And, that's the system working. That's the system working. That's an argument against the need for prior restraint.
To a reasonable person, this clearly shows that they should not have been used in the first place. Academic studies conducted at the University of Maryland and at the University of Michigan have shown a rise in the use of these agreements, reducing wages, job mobility, and entrepreneurship. When abused, they keep workers trapped in low-wage jobs where they are dependent on government benefits to make ends meet. An unintended consequence of a non-compete agreement is that it limits someone's greatest leverage and freedom, the ability to leave their current job for another. That freedom.
No, that's not an unintended consequence. That's the intended consequence. The idea is that as an employee, you have value that they want to keep. That's why they pay you more. See, here's the problem. Here's what the representative doesn't seem to understand. Whenever there's an agreement, a contract between two parties, there's a give and take. There's a meeting of the minds, and in a voluntary contract, you have an equal exchange of value, or at least the economic forces drive it towards a more equal exchange. Because if there's an agreement that's lopsided in favor of the employer, the employees want to go someplace else instead, and vice versa. That's the nature of contract law and supply and demand, is that when you have free entities that get together and say, the employer says, your time and labor is worth more than the money I want to pay you, and the employee says, your money is worth more than my time, they come to an agreement. And if the government comes in and says, you can no longer have this agreement, and in doing so, takes the value away from the employer's alternative is to either A, not renegotiate, the contract is now illegal, so the agreement is over, so the employee loses his job, or they renegotiate, and the employer says, since you can no longer give me the value of the non-compete, which is essentially the value of your loyalty, I have to pay you less. So what happens if the government comes in and says, you can't have a non-compete agreement because you're a low-income employee? Either you lose your job or you get paid less. That's the reality of what happens when the government says, this thing that was of value in a contract you can't have anymore. Then now they say, you have to get paid less because you're worth less to us, because we can no longer take in the value of retaining you. You're more likely to leave more easily. Therefore, we pay you less because now you're worth less to us. That's what the government will do if they pass this law. Okay, I'm going to move on here because we could talk about this for a long time. Let's now look at a bill that has not yet been heard in committee, but soon will be. Let's go over and look at another bill. This is House Bill 5217. This is a bill which, according to Michigan Votes, in their description here, permit student athletes to earn endorsement revenue. That's a misleading summary. That's not what the bill does. But the description's a little more accurate. To prohibit colleges or the NCAA or other organizations with authority over intercollegiate athletics from prohibiting a student from participating in sports if the student has received compensation for the use of the student's name, image, likeness, rights, or athletic reputation, or if the student hires an agent. So here's what that bill does. So is this a bill that is expanding freedom or restricting freedom? Let's read it. Let's not read the entire thing word for word here. Let's see. Section 1. Paragraph 1 is a definition. Paragraph 2. A post-secondary educational institution, that's a college, shall not uphold any rule, standard, or other limitation that prevents a student or the institution from fully participating in intercollegiate athletics or earning compensation as a result of the use of the student's name, image, likeness, rights, or athletic reputation. Earning compensation from the use of a student's name, image, likeness, rights, or athletic reputation shall not affect a student's scholarship eligibility or renewal. That's the gist of the whole thing, but let's just briefly look at the rest. And I'm not going to even read them word for word. The important thing is, as it says here, Section 2, an athletic association, conference, or other group, including but not limited to, etc., shall not do A or B. Section 3, a college, athletic association, etc., shall not do either of the following. Section 4, for purposes of this act, an athletics grant in aid or stipend scholarship from a post-secondary educational institution, etc., 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 shall not revoke or reduce, etc., etc. Section 5, a post-secondary educational institution, athletic association, etc., including not limited to, etc. Where does it say? Where's the shall not? Here we go. Shall not interfere with or prevent. 2, an athletic association, conference, etc., including but not limited to the NCAA, shall not prevent, etc. Paragraph 3, professional representation by an attorney, etc., shall be by persons licensed in the state, so shall not be by an unlicensed person. Section 6, a college athlete shall not enter into an agreement. A college athlete, you cannot do this. Paragraph 2, shall disclose, shall not fail to disclose, etc. So, I mean, and of course, that's what a law does. Laws don't say what you can do, they say what you can't do. So the only way this bill would, as the short title of the bill on michiganvotes.org says, let me go back over there, permit student athletes to do that, would be if it was to repeal some prohibition. This is not repealing a prohibition. This is introducing prohibitions. So again, you have the question, what happens when the voluntary agreement that a student athlete has entered into with his university is now illegal? What happens? Well, first of all, let me make an important observation here about how this affects different colleges differently. When we think college sports and we think about athletes that can't earn compensation, you're thinking about the college sports you see on television. And some schools, the Big Ten, they make a lot of money with their college athletics. But the vast majority of colleges don't make any money in athletics. Most of them lose a ton of money in athletics. If you're not making a huge amount of money, with sports on television, of course we all know, U of M and MSU. But Oakland University, Eastern Michigan University, they don't make money on their sports. They lose money on their sports. Well, they don't lose money, but they spend a lot of money on their sports. It's built into the cost of tuition. So what happens in those colleges or private colleges if they say you no longer can have an agreement where only the university can make money on sports? Because universities, of course, make money on licensing agreements and, of course, on endorsements and so on and so forth. And their agreements to the students are, you want to do this for free because A, you enjoy it, B, there's celebrity involved in it, C, you might build a career off of it. So there is still value. I mean, that's the reason why students voluntarily agree to play for free. It's because there's other value to it. So here again, you're abridging the ability of the student and the university to enter into a voluntary agreement. I mean, there's like the South Park episode where they compare the student athletes to slaves, but they're not. They enter into these agreements voluntarily because they want to, because it's of more benefit to them than if they did not. So along comes the government and they say, the agreement that you have is now no longer legal. So what happens? The cost of sports goes up. The cost of tuition goes up, first of all. Second of all, the actual investment into the sports goes down. And now here's the funny thing. According to this bill, it applies to all colleges, a public or private institution in the state that offers a degree in a course of study beyond the 12th grade. So all colleges. Now here's the funny thing about Michigan. We have what's called autonomy in our state constitution for our colleges and universities. So if this becomes a law, our state universities will sue the state and say, you can't do this because the Constitution says that you, the legislature, can't interfere in our business affairs. Now, they could lose or they could win. And Rep. Riley's office has looked into this extensively because we have the Campus Free Speech Bill. This is a bill that the colleges have already said we don't think it's constitutional. We think it is, because in that case, it's about campus free speech. It's a bill that simply upholds the constitutional rights of students. But this bill is talking about the athletics, the business affairs of the school. This is a much tougher time in court. And if the universities win, guess what? This won't even apply to the Big Ten schools. It will only apply to the private colleges that are already losing money hand over fist. So what's going to happen to them? Their sports go bye-bye. So the students that voluntarily compete for free because they enjoy the sport and they want to compete, those programs go away. That's what happens when the government interferes with the voluntary association of the employer and the employee. So I think with that, I'm going to wrap it up. I hope this has made sense. If you have questions, leave them in the comments. And again, this is basic free market economics, but I haven't seen a very good article that explains this very well. So, if you find something that's worthwhile that we can perhaps pass around to our colleagues, that'd be great. So feel free to leave that in the comments. Hope this was helpful. Hope this was informative. If you have any questions, leave a comment. Thanks so much. Hope you enjoyed this. Have a good night, everybody.